thank you so very much for joining me again today on the Creative Legals platform. So I'm going to start by discussing breach of quiet enjoyment. Most tenancy agreements, whether commercial or residential, will include an agreement on the part of the landlord for quiet enjoyment. For the purposes of today, we focus on residential matters, but the same principles apply to commercial properties. Breach of quiet enjoyment is a covenant that is contained in most leases or tenancies. If it's not expressly stated, it will be automatically implied, meaning even if it's not written into your contract, the law will consider your contract as if it had it. The principle of quiet enjoyment ensures that a tenant is free from disturbances and disruptions. Interestingly, the quiet part of quiet enjoyment does not relate to noise. The phrase quiet enjoyment should not be taken per literal meaning. It does not mean that the tenant has the right to enjoy a quiet property. Instead, it means that the tenant has the right to use their property, but without unreasonable or unnecessary interference from their landlord. It must be distinguished from noise nuisance, which I'll discuss in a separate episode. Let's share some examples of breach of quiet enjoyment. For example, a landlord is visiting the property without prior appointment or notice. This could be to demand rent, this could be to carry out inspections, this could be for whatever reason. But the material point here is that the landlord is visiting without a prior appointment. The landlord is visiting without prior notification. That in itself could amount to a breach of quiet enjoyment. There are exceptions, and this could be where the landlord's attendance is reasonable in all the circumstances. This could be because there is an emergency and therefore the landlord didn't have the ability to give the tenant the requisite prior notification. So there are exceptions. So that's one example of exceptions available. The next example would be where the landlord is harassing the tenant. This could be verbally or in writing, but particularly with the aim of trying to force the tenant to leave the property. That is more likely than not to be a breach of quiet enjoyment. The other example could be where the landlord does this indirectly by sending agents or workmen to the property without giving notice. So those are three classic examples of a breach of quiet enjoyment in residential matters. Until next time.